Objection, Judge, he's leading the witness. You want to know why the attorney said that? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. I was asking my medical expert questions on the witness stand, and I was asking him leading questions. Doctor, isn't it true you went to this medical school? Yes. And doctor, isn't it true you did your postgraduate training at this facility? Yes. And isn't it true you are board certified? Objection, Judge, he's leading the witness. And it's true, I was leading my witness. Now what does that mean? It means I am asking a question to which the doctor only has to answer yes or no. That's all he has to do. I'm literally putting words in the witness's mouth. I do that so that the jury can understand who my expert is. So I don't have to sit and ask the doctor, okay doctor, where did you go to medical school? All right doctor, where did you do your residency training? And are you board certified? And in what specialty? Establishing the doctor's credentials, I'm entitled and allowed and permitted to go ahead and ask leading questions just for that portion of the exam. So now, once I've completed that and the jury gets to see who this doctor is, to see what his credentials are, to see how much experience he has, now I have to ask the doctor open-ended questions. Doctor, tell us more about that. Doctor, have you reviewed the records at my request? Yes, I have. Well, tell us, doctor, what type of records did you review? Rather than saying, doctor, did you review this record? Yes or no. Did you review this hospital record? Yes or no. So instead, I'm turning it around. I'm simply now asking an open-ended question. Doctor, tell us what you reviewed. So can I ask leading questions when I'm questioning my own witness? The answer is yes, but only as to preliminary matters, to establish the doctor's credentials, and then I have to turn it around, then begin asking open-ended questions. Now, why is that done for a witness that I'm putting on the stand to support our claim? The reason is that the jury and the judge doesn't want to hear me putting words into our witness's mouth. Instead, they want me to ask open-ended questions so now the jury can evaluate for themselves what the doctor is saying. They can evaluate his credibility. They can determine based upon the doctor's own answers whether or not the doctor is credible. Who, what, where, when, how, why. And now it gives the witness an opportunity to tell us in their own words exactly what happened. Mr. Witness, tell us more. Explain to us what happened then. And again, the jury gets to see firsthand, exactly in the witness's own words, exactly what happened. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what happens during the course of trial when I put a witness up on the stand and begin asking leading questions. In all likelihood, I will get an objection from the defense attorney that says, objection, Your Honor, he's asking leading questions. He's leading the witness. So now you know a little bit more insight about why we do that and what the likely response will be. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something that I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a fantastic day.